Well, good afternoon, everybody, and welcome back to the COPEC Daily Financial Wellness Webcast. My name is Jerry Snyder, and I'm going to be your host today. Jay Linder and myself share those duties, and I'm happy to be with you today. We're going to feature Russ Golowin as our guest speaker today, talking about beneficiary inheritances and other important estate planning issues. Once again, just a reminder, we start every day at 2 o'clock, and we're happy to have you with us again. From 2 to 2:30, we have our guests talking in a conversational way, and then at 2:30, we go into our question and answer period. Certainly ask questions as we go along, and we'll get to those as we go along. Now, many of our speakers do have a financial tie to the financial industry, and some of them also are on the board of directors of the COPEC organization. So we do want to have some disclosures in that regard. And I'm going to silence myself for just about a minute while you can look that over. Thank you. Well, some of you might be new with us with COPEC, so I wanted to mention briefly that COPEC, Central Ohio Professional Education Council, is a nonprofit organization. We started back in 2004, and it's strictly for the purpose of providing good, effective communications and education at a no cost and no obligation kind of format. So we are doing the daily COPEC wellness programs live stream every day, as we've mentioned. We always make a little caveat. Sometimes our connectivity has a problem. So if that is the case, we appreciate your patience, and we'll get back up and running just as soon as possible. Again, questions will start at 2:30 on these programs. And the only exceptions is holidays. We will take holidays off, so you wouldn't be tuning in for those. And again, we invite you to share these informational sessions with people that you know or think might benefit as well. And on the right side there is a list of many of our speakers who have very in-depth knowledge on their field of knowledge. So today, again, we're doing the daily broadcast. If you go into the COPEC website, copeceducation.org, you'll see basically 6 tiles, which are easy to access, and it will tell you a lot more about the available programs that we have, starting again with the daily programs. You can see here in the yellow blocks there that we do arrange these in advance, and so you can look ahead. We would love to have you every day, but there may be certain programs that, again, you want to focus in on. And of course, we do have the kind of a full month calendar, as you can see here, which will let you look at these programs in advance. Retirement Decisions is a program we run 2 or 3 times a year. It's a very in-depth program for maybe people a little closer to retirement or want to look ahead. And so those are available. We've had those at the Fawcett Center. We hope to return there, but they're going to also be in a Zoom format as well. In-depth information on the state programs as well as other retirement programs. And then, of course, on Fridays, Financial Wellness Fridays is a tile that we invite you to access, and it will show you more of a lecture type series that we're offering, and we're able to get in more in depth on a lot of the topics of interest. And then if you're a part of an organization or a nonprofit organization or a company organization that you would like us as COPEC speakers to come in for wellness programs, we invite you to take advantage of that. And then finally, today we wanted to mention that there are 15-minute consultations offered as well. Some of the items might stir up some personal interest, but private interest in certain topics, or maybe you have a question that didn't get resolved, so you can certainly access that tile and make an appointment to to talk with us individually. So let's get on with the program. And again, it's my pleasure to introduce Russ Golowin. He's an estate planning attorney here in Central Ohio with special education in elder law issues. And so I'll let Russ mention a little bit more, but you know, the whole area of estate planning can be rather confusing, and many aspects of it. We're going to touch on beneficiaries and inheritance, but I'm just going to ask a question to get started here. What is some of the common misunderstandings, Russ, that you run into?
Thanks, Jerry, and thank you everybody for joining. Really, this might sound strange, but the biggest misunderstanding in estate planning, and really the biggest mistake that I see happening over and over again, is just a failure to understand that how you own your property is critical. And more specifically, to know that a will does not control a beneficiary designation or property that has a joint owner. So Jerry, what I'm going to do real quick here, I'm going to share a slide that I have, and that'll help everybody see what I'm talking about a little better. So here we go. Everybody take a look here. On the left, there are 5 ways of owning property, at least in my definition, there are 5 ways. And the first one on the left is jointly owned property. So that would be a bank account in 2 people's names, for example. It could be a piece of real estate that you own with your brother, something like that. Then there are number 2 through 4. These are really ways of adding a beneficiary to an account. And so you might do that on an annuity or a life insurance policy. You might have bank accounts that are payable on death to someone else. You might have real estate that's transfer on death. All these 3 things are doing the same thing. They're saying, when I die, I want this account or property to go to the beneficiary. If you have a jointly owned bank account, if I die, it goes directly to the other joint owner. And a lot of people just don't understand that. They think that if they have a will that says everything should go to their spouse or everything should go to their brother, that that's what's going to happen. But if you take a look here at the bottom, you see only property in your name alone is controlled by the will. And that causes a lot of problems, because if we don't have updated beneficiary designations that point to the correct person, you could have a very perfect and legally valid will, but it doesn't control a majority of your property because it's not controlling any of these accounts 1 through 4. Does that make sense, Jerry?
It does. And I don't know if you'll get to this. I know a lot of people have questions about how to own their house. You know, how should they title their house, and how does that get passed if one of the owners deceases?
Yeah, that's actually a good point. Right here below jointly owned property, I made a note about that, but let's talk about that in a little more detail. This is specifically for real estate, so a house, a condo, just vacant land, things like that. If you own property jointly with someone else that's real estate, to know where it's going to go who dies, you have to look at the deed. The deed will give you a clue. So if you get that deed and you see that it says so-and-so transfers to Russ and Jenny Golowin for their joint lives, remainder to the survivor of them, what that means is it's a survivorship deed, and when the first person, the first joint owner dies, the ownership is transferred to the surviving joint owner. And that's without having to go through probate, without having to spend a lot of money in court. That is how many married couples want to own their property. If it doesn't say for their joint lives, remainder to the survivor of them, that doesn't necessarily mean it's wrong. It just means if I died first, my half of that property is going to go through probate, and it'll go to wherever my will says it should go. Or if I don't have a will, it'll go wherever state law says it should go. But the point is, it doesn't automatically go to the surviving owner. So I'm not saying everybody should have a survivorship deed. I'm just suggesting if you would want the whole to be owned by the survivor, then you might want a survivorship deed to avoid court, avoid probate. But if I own a rental property with my brother and I want my half to go to my kids if I die, well, then I don't want a survivorship deed. So you really just need to consider the situation and then make sure your deed reflects your wishes.
Well, Russ, if one of the spouses does decease, then should the title be changed again in some way?
Yeah, if let's say that it's a married couple and it is a survivorship deed, well, that's good. If I die, then my wife has to take a certified copy of the death certificate and make an affidavit that says that I passed away and record that with the recorder's office. Probably cost, about $50 in recording fees. And then that ownership is transferred. It's not difficult or time consuming at all. If the married couple, again, if they were married, jointly owned the house, but it was not a survivorship deed, that's when if I die, my wife has to go through probate with the 50% interest of the house that I owned. And it'll probably get to her because I probably left my assets to her in my will. But unfortunately, you have to go through court, and there will be cost and time involved with that probate process.
Another thing that we run into a lot is parents wanting to put their children's names on a lot of their assets. Is
Right.
that a good idea, or how do you feel about that?
Yeah, I'm reluctant in general to name children as a joint owner. And that could be on real estate, or it could be on bank accounts. The reason, or a couple reasons why that is if I put my son's name on my bank account, well, then he's a joint owner, and the first thing he can do is take all the money out and buy himself a brand new truck that he's always wanted. And that's not illegal. He's an owner, he can do it. So number one, there's a danger that my child might take that money. Now, I trust my son, I'm not worried about that. But danger number two is, well, now that he's a joint owner, when I die, he's going to get that whole account. And what if I have 3 kids and I really wanted everything shared third? Well, now my son gets it all and he does not legally have to share any of it. So that's danger number two. You're overriding your instructions in your will. And then number 3, even if I believe that my son would share with his other 2 siblings, what if he dies before he can write them a check? Or what if he's mentally incapacitated? Or perhaps he has lawsuits, creditors, bankruptcy, divorce issues. He could be prevented from sharing that money with his siblings, even if he was trying to do the right thing. So I much prefer having a power of attorney. I could name my son as the power of attorney. And so then if I become incapacitated, he can pay my bills and do what he needs to do with my account. But it does not change where the money in the account goes when I die. And he does not have the legal ability or right to spend that money in my account. So most of the time I'd prefer a power of attorney over naming someone as a joint owner on an account or on real estate.
I get a question too on how often should you update your will or look at your different titling or beneficiaries and things of that nature? Is there a rule of thumb?
Yeah, that's a good point, Jerry. Wills don't necessarily get too old. I do think that a financial power of attorney should be redone every 3 to 5 years because banks don't really like to accept them after a certain period of time. But there really isn't that problem with the will as long as you can locate the original. Probate court wants the original, so make sure you keep track of it. The biggest issue, I think, concerning our topic today is just to make sure that your beneficiary designations are correct and that you have proof that they were made. Because believe it or not, some financial companies can lose these beneficiary designation documents, and then somebody dies and the company says, well, we don't have anything on record as far as where this money has to go, so you're stuck going through probate. So I would recommend always keeping written verification of who the beneficiaries are with your other estate planning documents. For example, I like to do binders to keep everything together. And in that, I like to make a spreadsheet that lists all the house, the car, checking, savings, brokerage accounts, retirement accounts, and then on the column to the right, who the beneficiaries are and that was actually taken care of. And then I would throw in there, again, the written proof that the beneficiaries are on file with the company, and then even maybe put a statement, a recent statement in there, just so that if something happens to me, whoever has that book, which is probably going to be my executor or trustee, they then have the account number, they know the phone number from the statement to call the company, and it's just really nice and organized. And if the company says they don't have record of the beneficiary, they can just pull out that piece of paper and say, look, here's a copy of the beneficiary designation. You may have lost it, but here it is. So you can avoid probate by, doing some extra work and keeping those in hand.
This might be getting a little bit beyond the actual topic for today, but it reminds me too, I've had so many clients, or a number of clients at least, have difficulty in presenting the original will. They somehow, it gets lost or something's happened to it. And it is necessary. Is that true, Russ, that an original will needs to be presented at the time of death?
Yeah, you do need to present the original. And yeah, I've had people that run into trouble there. You have some options. I mean, number one, if you have a nice safe at your house, that could be a nice place for it. Of course, you need to make sure people know it's in the safe and how to get in it if necessary. But there are also some other options, or I guess one in particular I can mention. In many counties, you can pay a fee, and the probate court will take that will, whenever you want. You could be 20 years old and file your will for safekeeping. And the court will keep that will forever for that cost, which in Franklin County is $25 per will. I think in Delaware County it's $35, but it's not very expensive. And that way, if you pass away or when you pass away, your will's already at the court. You don't need to worry about it burning up in a fire or getting destroyed in a flood or anything like that. It's just at the court. So that is a good option for a relatively small fee to get some good peace of mind that you're not going to misplace that will. Because if you do, the issue is you have to have a hearing at the probate court where the witnesses to the will show up and testify that this photocopy that hopefully you can find is the same as the original that the witnesses signed, which is always kind of interesting because I don't really think there's any way that they can know for sure the copy is the same as the original. But more importantly, it takes court costs, attorney fees, the witnesses' time, and it can just be a frustrating thing when you're already going through a frustrating process. So make sure you keep those original wills safe and where they can be found.
Russ, you've mentioned a number of important estate planning documents in our discussion so far. And again, the nice thing is we're going to have a number of programs throughout the year, and also these Fridays, these Financial Fridays, It's going to allow us to get into a lot more depth. But would you want to just tick off when somebody goes to an attorney and they're going to, I guess the attorney is going to do a package for them of a number of different documents. Can you just maybe tick off those documents again as to what people should look for?
Sure. And by the way, I think it's September 7th. I'm going to be doing a longer presentation called Estate Planning Essentials, where you'll actually see this diagram that's on the screen again, and we'll go through many different documents and topics. So if you're interested in these types of things, that might be a good program for you or your loved ones. To answer Jerry's question, yeah, I think really for people that like to get everything taken care of that really should be, honestly, the moment you turn 18 years old, you should create at least a simple will, a financial power of attorney. That's a document that says, if I'm incapacitated, I want this person to be able to pay my bills, write checks out of my account, pay my taxes for me, do those things. A healthcare power of attorney names your healthcare decision maker in case you're unable to make your own healthcare decisions. You might have a living will if you want to direct that you don't want life support if you're permanently unconscious or terminally ill. Some people like that, some people don't. So that's why I say maybe for the living will. There's a HIPAA authorization that can make sure your loved ones can be informed of how you're doing at the hospital, make sure they can visit you, get the information from the doctor. That's critical. And then one good idea that is more important in some families than in others is a declaration for funeral arrangements. That says, I want this person to be in charge of my funeral, burial, cremation, whatever it is that you want. And, in some families, it's sort of clear who's in charge, but especially in families where maybe there's a second marriage and children, it might not be clear if the new spouse is in charge or if the children are in charge. And so it's just always better to have a document that says the funeral home is legally bound to follow the instructions of the person that I direct. So there's no trouble, there's no fighting, there's no confusion. But yeah, I would say most important for just about everybody, will, financial power of attorney, and the healthcare documents and the declaration for funeral arrangements. That's a really good base to build on, and we'll cover many different situations that might arise.
And that brings to mind, and again, you may cover this in much more depth at a later program, but what it brings to my mind is your estate planning team, I call it, picking out the important people to fulfill certain roles that are important in this estate planning arena.
Right.
Comment on that maybe a little bit?
Well, sure. Most people, or I guess I should say, people that don't want to try to make their own estate plan from a book or from the computer or from forms they buy at the office supply store are going to be using an attorney. And it's always best to pick an attorney that really focuses on estate planning issues, so they're familiar with some of the pitfalls that can occur if you don't have things set up a particular way. If you're dealing with somebody who might be concerned about long-term care, meaning nursing home, assisted living, or even in-home care, you might work with an attorney that has a focus on elder law issues, because that is a whole nother arena. It can be fairly complicated dealing with Medicaid or veterans benefits. So maybe an estate planning / elder law attorney is what you want. If you're concerned about the long-term care issue, you're going to want to look at a certified financial planner who can design long-term care insurance policies. And hopefully they also would be able to take you through some basic financial planning considerations, and perhaps even investment of funds for you if that's a goal of yours. So attorney, the certified financial planner. And then there are all sorts of other folks as well. You might want to pair up with a tax preparation expert or a certified public accountant. Have all these three working together. And then, of course, there are in-home healthcare agencies. There are geriatric care managers, if you're talking about people that are advancing in age. Really, there are so many different groups of professionals where if you can get them all on your team and have them working together, it'll make all of this much, much easier, especially if you give them the power to communicate with each other. So you have the estate planning, you have financial managers, and you have tax all together, just as an example. That can make these things very easy, not only for you during your life, but also if you pass away, then taxes can be prepared, everything can be done with court if necessary, all in a financially responsible and smart way. So I think the team approach for people that are interested can really work out well. Something to look into.
Well, as you see, I'm bringing up a screen. We're kind of running out of time, and that's the frustrating thing a little bit, is we have to limit our time a little bit. Again, that's why we're offering so many of these different programs at different times. So, well, Russ, I can't thank you enough for joining us today. And I want to continue to invite people to visit the website, the copeceducation.org, to look at programs coming up, and also take advantage of that 15-minute consultation if we can be of help individually. That too, again, can be found on the website. So we'll sign off for now and thank everybody again for joining us, and hope we've been of help to you.
Yeah, thank you, everybody.
Take care.
Thanks, Jerry.
Uh-huh.